Hello folks, Dick Fairburn here. Wrapping up my series talking about step 1 and step 2 of an armed confrontation. Step 1, winning the fight, going home alive. Step 2, the aftermath. What's going to happen in court, things like that. There's kind of 3 little short topics I want to talk about to wrap up step 1 and then move on then to step 2 issues. So I'm going to cover all 3 of those short ones in this video, and I'm going to talk about rules of engagement, which we have alluded to before, liability protection that you really ought to have, and what should we do about restricted carry locations. So stick around, and I'll give you my thoughts on these 3 last important issues in step 1, winning the fight. Okay, let's review the rules of engagement. I think everyone has heard these in your course of your life, but they are worthy of going over again. The use of deadly force by citizens. Now, I covered this topic in one of my early ones, talking about the need to retreat from a threat in some states, while other states you can legally stand your ground and confront anyone who attacks you. Each state has its own statutes related to the use of force, but they're similar enough that we can kind of give a generic overview. You are legally justified in using deadly force to protect yourselves and people around you from a threat which reasonably poses death or great bodily harm to you. Now, this does not necessarily mean that your adversary has to be armed with a firearm, a cutting instrument, a baseball bat, or some other, obvious kind of weapon. In some cases, a smaller individual may be justified in using deadly force to protect themselves from an overwhelming attacker who may be attacking them with nothing more than, hands, fists, and feet. In one case that I'm going to talk about in a future video, Daniel Penny in the New York subway system used force on a man who was not armed, but Daniel felt was posing a severe threat to both him and the other people on the subway. And he was recently exonerated in criminal charges. So they don't have to have a weapon, but generally that's what we're looking at when you use deadly force on another human being. You are not generally justified in using deadly force to prevent the theft of property. Now, one commenter a couple of times back told me that you could do that in Texas. I have not researched that, so I'm not going to state one way or the other. But I find it kind of curious that in the Old West, stealing a horse, leaving a man afoot, was both a shooting and a hanging offense. I guess we've become more civilized somehow. Now, I heard an instructor in a class one time say that if you were not in immediate danger, but others were. Let's say this is maybe you're at the mall and someone is going active shooter in the food court down the way. You hear the shots being fired. This instructor expressed the opinion that if you were to run to that food court, put yourself in danger by doing that, and then engage that shooter, that you wouldn't be justified because you were not originally in danger and that you willingly put yourself into harm's way. I don't follow the logic in that. I think if you were to do something like that, you did run to the sound of the gunfire and that you did stop a killer who was, engaging a bunch of innocent victims. I think first of all, you're going to be the hero. And, what can the prosecutor say that you did wrong, that you exposed yourself to danger? Luckily, it's not really against the law to be stupid. If it were against the law to be stupid, most of us would have been in trouble at probably various points in our lives. And so I think you can, in some circumstances, probably move towards the danger, move yourself from a safe location to that dangerous zone of say, gunfire, and then deal with it. I'm sorry, but I don't follow the logic in what that instructor proposed. Now, as an armed citizen, you are not justified in using deadly force against a threat which has ceased to be a threat, either by dropping their weapon and running away, or because they're down and they're no longer posing a threat. So when the threat ends, your justification for shooting ends. In the same vein, adding a couple of extra rounds after the fight is over is a bad idea. Unlike the John Wick movies, a finisher shot in the head is simply going to go a long way towards getting you prosecuted. Now, if you shoot and put an attacker down, it is perfectly logical to keep that person covered with a firearm. You need to be satisfied that they are no longer a threat. And if you can, move their weapon away from them, something like that, then by all means do so. Remember, when the police show up, you do not want to be the guy with a pistol in your hand pointing it at someone down on the ground. The cops don't know who you are. They don't know good guy from bad guy when they show up. They're coming in like thunder, and if you can get that pistol put away in a holster or on the ground, get your hands up and tell them, I shot him. He was killing people, or whatever you need to say to identify yourself as the good guy. Okay, liability protection. I mentioned Daniel Penny. When I talk about that case study, I'm also going to talk about Kyle Rittenhouse. Both of them won their criminal trials from the use of deadly force, but we can only imagine what the legal bill was for their defense. So there's a lot of money involved. And if you don't have some kind of liability protection, if you're carrying out in society today, then you're pretty foolish and you need to look into it. Two general categories of what you can get as liability protection, and there are a lot of vendors out there that are more than willing to take your money. Insurance is the most common form of protection available, and most of them have dollar value limits. And so how high you want those dollar value limits to go will dictate the price you pay for that insurance coverage. Now, beware of one thing. There are some sales pitches thrown out there by competitors. This is getting to be a pretty cutthroat field. A lot of vendors, and some of them are kind of nasty. Accusation has been labeled against one of the biggest carriers out there, one of the largest insurance providers, that they have not covered a couple of people who had been charged criminally. The truth of this is that most states restrict insurance companies from paying claims associated with criminal behavior. So in some states, an insurance company's hands are tied about what it can do if you get convicted of a crime. So bear in mind that there are those legal restrictions, and the company that most of the attacks have been lodged against, I know for a fact that they have gone ahead and covered in a couple of instances where legally they didn't have to. So check your companies out, see what their track record is, and vet them before you decide what to do. The second form of protection is really kind of a retainer system with a law firm. And what they are guaranteeing to provide you is all the legal coverage that you need, and that is covered by your monthly or annual premium. So there will be no additional legal expenses. The ones I'm aware of also have a little side insurance kind of coverage that if you happen to lose and there is an award or a fine associated with losing your cases, that will be covered as well. But check into that. See if it just covers your legal services, or if it will expand out to maybe get you bailed to get you out of jail when you're arrested, or cover any settlements at the end. For the active and retired law enforcement personnel who might be watching, the best deal out there for you is protection through the Fraternal Order of Police. If you are a member of an FOP lodge, or you are eligible to join a lodge, their coverage is, I think, the best there is for the price, and it's what I use personally. I get unlimited dollar value LEOSA protection. That's Law Enforcement Officer Safety Act. It's a federal law that gives active and retired cops nationwide concealed carry. It's $75 a year. Now, obviously you have your FOP membership above and beyond that, but, a lot of us were members anyway. So for 75 bucks a year, you get attorneys who are very well versed in defending self-defense shootings. And as I said, there's no limit. No limit to the legal fees, no limit to the settlements, awards, and they're going to, I believe, I'd have to read up, but I believe they are guaranteed to bail you out of jail if you get arrested in this process. So that's what I use. Now my wife chose to use U.S. Concealed Carry Association, USCCA. That's the coverage she got when she first got a concealed carry license. Now, like other vendors, they have several different levels of protection, increasing price structures for higher levels of limits. I will make a disclosure. Now, after my wife had been with them using their insurance for a number of years, I signed on with USCCA. Their parent company is Delta Defense, and I am a writer for Concealed Carry Magazine. So while I'm on their masthead and contribute articles to almost every issue, I have no association with USCCA self-defense coverage, and I do not specifically recommend their product above anybody else. All right, the last topic I want to talk about in this video are restricted carry locations. Now, these vary widely from state to state. We all face some locations where concealed carry is not allowed, and this is universal. Weapons are restricted in courthouses, or at least in courtrooms, both state and federal. You cannot carry in a jail, prison, or any other kind of lockup. U.S. post offices and most other federal buildings are off limits for concealed carry. Military installations are generally off limits for concealed carry, even in most cases for the military people that are assigned there, which I find repugnant myself, that they can't be armed on their own basis. Now, the post office restriction is being fought out in court, and I believe there has been at least a preliminary ruling that said that there is no reason to have a post office be a restricted area, but that is far from being settled. But it is an issue that's being, waged through the court system. Most states, since every state now has some form of concealed carry license, most states also allow businesses to post a sign on their entrance banning concealed weapons if they so choose. But these are kind of interesting. Here in Illinois, when I lived down in Springfield, I worked for the state police in the capital and lived in Springfield. They had a large mall. I would occasionally go to the mall. If you went to the mall entrances, the generic entrances into the mall hallways, they were all posted with the sign that prohibited concealed carry. But if you went in through some of the businesses that had, locations on the outer ring of the mall, in particular Sears, and a lot of times I would go in through Sears because that was just the most convenient place for me to park on the way home, it was not posted. So there was no prohibition about going into Sears with a concealed carry weapon, and obviously from Sears I had direct access to the rest of the mall. So you're going to have to make some decisions on some of these things. If you're going to, and my recommendation is to you, follow the law. Doing anything less could cost you your concealed carry license or possibly even criminal charges in some states. So if you know there is a restricted spot to go, my advice is don't carry there. Do I live by that myself? If I'm going to stop at the post office on the way home, run in, drop off a quick package, do I always lock my pistol up in the console of the truck? I'm going to plead the fifth on that. When I went to that mall, I went in through Sears. I did not lock my pistol up in the console. This issue is not really settled in either law or in the whole climate of carrying concealed weapons. For example, there's a federal law banning firearms within 1,000 feet of a school nationwide. But most federal officials will admit that that law is almost certainly unconstitutional, and they rarely use it to charge anyone. It may be an added charge to some kind of criminal, but they'll often just dicker that down in the plea bargaining process. That 1,000-foot restriction around a school does not even allow for people who have residences within that 1,000 feet of a school. So technically, by that law, those people have been denied their Second Amendment rights. The law is on the books, and it should be removed, but it hasn't been removed. Now, most states do restrict, many states at least, do restrict carrying in schools. So be cognizant of that. Some states, like New York and New Jersey, have changed their laws after the Bruin decision, when they were forced to go to shall issue type permits. And they've tried to essentially make their whole state a no carry zone. They've added parks, playgrounds, large public events, everything else that they can think of. When Illinois was setting the restrictions that went along with our concealed carry law, I had a little bit of input into the process, very little actually. And the state police official who was on the team setting up the regulations, I urged him, I said, hey, make sure they don't put religious facilities on the list of banned locations. And I said, and here's the reason why. One of my jobs at the academy, we were training rapid deployment for police officers. So I had a lot of information on active shooter events. And I told him, I said, within the last 2 decades, almost 1/3 of the active shooter events in the country have been at a church facility. So these are ripe areas for active shooters. So people should be able to be armed there, and specifically the church should be able to use their own parishioners as a volunteer security team to protect them. And we got that through. He was able to make that argument. But as I said, some states do restrict the carrying of weapons in church facilities, and I think that's a very bad idea. In general, I think restricted areas are a bad idea. I think most areas should be available for concealed carry. Now, I mentioned that retired law enforcement officers can carry nationwide under that federal LEOSA Act. Don't flame me with comments. I agree we should all have nationwide carry rights, but that has not yet come. The restrictions are somewhat less for LEOSA carriers, but there are still some specific regulations in there, and if you're a police officer, retired or active police officer, you need to be up to speed on that law, so look at those restrictions. So, as I said, what do you do about a restricted carry zone? My advice is comply with the law. Doing anything less is going to expose you to problems. Do I follow the rules, lock my pistol in the truck every time I go somewhere? Here's my philosophy. I am not saying this as a recommendation for you and your course of actions. This also points to why I'm such a believer in concealed carry as opposed to open carry. When I say concealed, I mean well concealed. An example, as my wife and I age, we spend more and more time in medical clinics, and a lot of medical clinics have the little sign on their door as a restricted area. If I happen to be in there with a well-concealed pistol, nobody knows I'm there, nobody knows I'm armed, nothing bad happens while I'm there, which is going to be 99.999% of the time, no harm was done. Those people were better protected. If they knew, they could say thank you, and I go about my business. But if I am in there in that circumstance and that 0.00001% of the time chance does happen, and some idiot ignores that sign on the door, takes a gun with him to shoot his ex-wife because of a divorce problem or something, and I'm there to put a stop to that active shooter, well, I think a prosecutor is going to have a pretty hard time filing charges on the hero. If you saved lives by ignoring that restricted carry rule, I think I'll take my chances. Now, I think we're going to see a lot of these restricted areas be legislated away. You know, if the Supreme Court continues to go the direction we think they're going now, we're going to see things open up. But until that happens, I urge you to follow the law. Don't do as I might do. As I get older, I'm not saying I was the toughest guy in the world, but I could hold my own when I was younger. I don't fight worth a darn anymore, and I don't even run very fast or very far. So if I'm confronted by some kind of deadly force threat in front of me, I'm going to have to deal with that with deadly force in return. Now, when I say I don't always lock my gun up in the console of the truck, that's because I spend most of my time in Mayberry. I live in a part of the country where I can probably get away with that. But if I lived in New York or California or New Jersey or even Illinois, north of I-80, up in the Chicago and Collier counties, I would have to rethink that, because there you are more likely to bump into prosecutors who are not going to have a sense of humor. They're not going to see you as the hero who saved lives. They're going to look at you as the evil, concealed carry crazy who kept their gun on them when they shouldn't have, and they're going to come at you with everything they can throw. So I recommend you follow the rules. As I said, as I get older, less physically able and a little bit more grouchy, I'm going to do my fighting with something that's a 9mm or larger. You do what you think you need to do. Folks, if you think these videos are useful to you, then I ask you to subscribe or resubscribe. Give me a thumbs up. I appreciate you watching these views. My viewership is continuing to climb, not real fast, but I think my videos are a little bit different than some of the more glitzier and you know, high profile stuff that's out there. But I appreciate you watching me. I really appreciate all the positive comments I get back. And thank you very much for watching. Be safe out there. Okay, we got them both here now. You ready? Bud got one. Ginger got one. Uh-huh. Oh, she missed it. She usually gets them, doesn't she, Bud? Mm-hmm. Okay, girl, last one. You ready? You ready? Yeah! That's all there is till next time.